This is Michael Clara coming to you from Salt Lake City, Utah. I'm doing a short podcast on a new self-defense law that went into effect here in the state of Utah last year in May of 2021. One of the things that has prompted me to make this podcast is I would call it, I guess, the overly cynical rendering of this new law that's been put out by Daniela Rivera of KSL News here in Salt Lake City. And I'll touch on that as I go along here as to what are some of my concerns about the mischaracterization that she's reporting about this new law. And I'll just touch on slightly here. I was involved in a self-defense incident in November 23rd of 2019 here in Salt Lake City, and it was reported in the news, but I don't want to go into any details of the facts of that at this point because there's still things in motion within the legal system. But I just want to refer to it to kind of explain the context of why this new self-defense law is of interest to me. And this is just a map of the incident, what happened that night when this stolen snowplow starts ramming my vehicle, disables my vehicle in the intersection. And then when I get out to get my passenger out of the vehicle so we could get out of the street and not get hit by oncoming traffic, the snowplow starts to come back. And I fire my gun at him in self-defense. And then he leaves and follows this red path that you see here. It looks like maybe he was going to go around the block and come back, but luckily for me and my passenger, there was two police officers literally a block away, half a block from us, and actually heard the gunshots and were able to respond. And I think that prevented this guy from coming back. And so, like I said, more about that. When I'm able to speak about it, I can dive into more detail on what happened that evening. But I want to talk about the process and the legal process. And so, as the Deseret News reported, I was arrested with 7 felony counts. And as most of us know, the police can arrest people on probable cause. That's the burden of proof that they have to establish, which is pretty low. And I understood that night. And so me being arrested was really inconsequential in this whole process. I guess in comparison to all the other stuff, that was the least traumatizing for me in terms of the victimization that comes to someone through when you get into the criminal justice system. And so Channel 2 News was there that night. And they report on, Jeremy Harris did a good report on self-defense or felony. Which is it? Based on the circumstances as they understood them at that point, it's a valid question that I think, we all need to explore and understand. And at the time, my attorney says that, that he didn't believe, and I don't believe, I didn't then, I don't now, that I should have been arrested or charged. And so, because in the law here in the state of Utah, it says that what I did, that this section does not apply to an individual who discharges a firearm when that individual is in lawful defense of self or others. ABC4 News did a story, I believe, the next month, and they quote the chief deputy, Jeff Hall, from the Salt Lake District Attorney's Office, who explains why they charged me. So I get charged the next month, and again, you get arrested, then you get charged, and Rosie quotes my attorney, Clayton Sims, who said, Clara plans to plead not guilty. And so I did go to an arraignment and pled not guilty. And then the next step that's going to happen is I'm going to go to a preliminary hearing. And what I did is I had hired Clayton Sims as my criminal defense attorney, and I also hired Mitch Velos to consult with. Mitch Velos is also a criminal defense attorney, but I just hired him to kind of consult with my criminal defense attorney because I wasn't sure how much my criminal defense attorney understood the concept of self-defense and the 5 elements of self-defense as spelled out by this attorney, Andrew Branca. And so once I discussed this with my criminal defense attorney, Mitch Velos did a good job at helping him understand these concepts. And then we go to the preliminary hearing, and I get bound over for trial. Because here in the state of Utah, and I believe it's the same in most states, you have a preliminary hearing. The police, and I was surprised to learn this. Like I said, I knew the police can arrest on probable cause. I had no idea that when you go to a preliminary hearing, that's all the district attorney has to do. The prosecutor, their burden of proof at a preliminary hearing is only probable cause. So the concept of self-defense, and my attorney, criminal defense attorney Clayton Sims, did argue this to the judge. He said, but Judge, this doesn't apply to him because he acted in self-defense. And the police, this is why, and let me back up here, the Deseret News quotes, Judge Todd Shaughnessy ruled Thursday that prosecutors met their burden of probable cause. To support 7 counts of felony discharge of a firearm, a third-degree felony, the judge said brief testimony from 2 Salt Lake police officers could be seen as favorable to either side. And what the judge said is, but he has to give it to the state in that case. So he did. So that's the process of preliminary hearing. So one of the things that I did is started looking at other laws. I had a book by Mitch Velos, and he outlines the laws from all 50 states. And these are the states, Colorado, Florida, Kentucky, South Carolina, North Carolina, and Kansas, that had a different concept, if you will, of a preliminary hearing and what a defendant could do at a preliminary hearing, and that a defendant that acted in self-defense. Then Mitch Velos' book was printed in 2013, so it didn't have in there the updates that Florida did to their law, and I believe we called it immunity from prosecution. But in 2015 and 2017, the legislature in Florida updated their self-defense law as it pertains to preliminary hearings. So, and basically what they ended up doing. So let me back up and say that in 2015, when Florida updates their law, there ends up being case law from the courts that kind of clarify the application of how things are going to work in a preliminary hearing. And then what ends up happening is the legislature puts that into law, and basically just says that once a prima facie claim of self-defense immunity from criminal prosecution has been raised by the defendant at a pretrial immunity hearing, the burden of proof by clear and convincing evidence is on the party seeking to overcome the immunity from criminal prosecution provided in. And I'm sorry, that's actually probably a court ruling, but you get the idea that there's 2 parts to it. One is that as a defendant, you have to demonstrate a prima facie claim of self-defense, and then the prosecution has to demonstrate by clear and convincing evidence that that's not the case. So in Florida, they call it immunity from prosecution. In the state of Utah, a bill was introduced in 2021 legislative session. It was called HB 227, and it talks about justification hearings. And so the went through the state legislature. And by the way, in my case, because of COVID, things got delayed. My incident happened November 2019. In 2021, I still don't even have a trial date. So I was able to go to the legislature and advocate for this new law. At the hearings, it has a hearing at the House of Representatives. I spoke at it, other people spoke, and the district attorney, his chief policy advisor, was there and spoke against the bill. And in fact, there were issues that she brought up that in the next version of the bill, some of the concerns that were raised by the Salt Lake District Attorney's Office was actually incorporated into the later versions of the law. And then one of the interesting things that she says here, that no one is saying that self-defense is not an important issue in this state, but self-defense is already something that prosecutors take into consideration when deciding whether to bring charges and what charges to bring. And I can tell you in my case, that didn't happen. That even though the law says that this section does not apply to an individual who discharges a firearm, when that individual is in lawful defense of self or others, I don't believe that the district attorney's office in Salt Lake County took that into consideration. A week or two later, as this bill is going through the legislative session, we had a hearing at the Senate, and I spoke at it. And then you have Will Carlson from the Salt Lake County District Attorney's Office opposing the bill. And he's saying that, this is just an effort to work around the preliminary hearing as we knew it then. So this is just a list on the left. It shows you all the dates. This bill was introduced in January of 2021, and then the governor ends up signing it into law March 16th of 2021. And then, so this bill becomes law here in the state of Utah, and it's under Code Section 762309 and under the justified use of force. And basically it says what I had read earlier about the Florida law, that there's two parts here other than, like I said, we call it a justification hearing. And it just says that the defendant makes a prima facie claim of justification, and then the state has the burden to prove by clear and convincing evidence that the defendant's use or threatened use of force was not justified. So again, this got passed in March. A few months later, in November 16th of 2021, we get this headline out of KSL. It's not working. KSL investigates unintended consequences of the new Utah self-defense law. And so I have a number of concerns with the way this was reported, but I'll just mention a couple here. And I believe that some of the reports in this by Daniela Rivera were misleading. For example, she says in her reporting of this new law that the Florida Stand Your Ground law had a significant racially discriminatory impact. Well, the problem is this is not a stand your ground issue. This has to do with preliminary hearing. So if there's issues with stand your ground, that would be a different story or different report, because as far as stand your ground goes, Utah was actually the leader in that. Our stand your ground law has been in place since 1994. We were actually the first state in the United States, followed by Florida in 2005, to do a stand your ground, and we've done a couple of versions since then to clean it up. Like here's the latest, I believe, was in 2019. So stand your ground law is happening in 30 states, and it has stuff to do, it does relate to a preliminary hearing, but it's not the same thing. And I don't know if she confused them or if I missed the point that she was trying to make by bringing up the racial bias that's inherent, that according to this report, and stand your ground laws. One of the things in her report, she points out that we're a very terrible guinea pig, according to the Salt Lake District Attorney Sim Gill. And she says here that outside of Florida and now Utah, Velos did not find any other state with a specific legal process. And I'm not sure what, I haven't asked, I meant to ask him before I did this podcast, but I haven't asked Mitch Velos if that's accurate, what she said, because it's not an accurate conclusion, I would say, because like I said, in Mitch Velos' book that was published in 2013, Colorado, Florida, Kentucky, South Carolina, North Carolina, and Kansas already had some version of the preliminary hearing issue that gave some protection to people that acted in self-defense. And since that time, since his book was published, these are all the states that I could find that actually had some version of this law that just passed in the state of Utah that has to do with preliminary hearings. So I'm just saying that it's inaccurate to say, in my opinion, to say that only 2 states have this and that now we're all guinea pigs over it. And according to District Attorney Sim Gill, we're bad guinea pigs, because of this new law. Another concern that I have that I take issue with Daniela Rivera's report is that she's talking about the 2017 law in the state of Florida, and she references a report that the legislature in Florida gave about this law, but it's actually referencing an old version of the law, because a couple weeks later, there's actually another report that actually reflects what the updated version of that law was in the state of Florida. The other concern I have is that, so what? There's a report anyways in the legislature as this newer version of their law was going into effect, but Daniela ignores all the case law that came out of Florida following the passage of that updated law, that again, Utah does mirror that updated law from 2017 out of Florida. But for example, in this Jefferson versus the state in 2018, one of the things that the appellate court in Florida clarifies that has application to here in Utah, that people are questioning this law, but like we have judges that say, well, we don't know what the legislature intended. What were they trying to do? Well, in Florida, the appellate court addressed that by saying, when the statutory language is clear, courts have no occasion to resort to rules of construction. They must read the statute as written, for to do otherwise would constitute an abrogation of legislative power. And I think that's something that message that we're not understanding here in the state of Utah for some reason. Then the other issue that's coming up here in Utah that the appellate court in Florida addressed is the legislature has imposed a lesser burden on the state, which is clear and convincing evidence, at a pretrial immunity hearing, with or without the defendant testifying than during trial. And then they go on to say, if the state cannot overcome an accused claim of immunity by clear and convincing evidence at a pretrial immunity hearing, it is less likely it can prove beyond a reasonable doubt at trial that the same acts were not justified in self-defense. Now, what's significant about that is that if a case gets dismissed here in the state of Utah under this justification hearing, then because the prosecution couldn't meet the lower burden of clear and convincing evidence, the appeals court is just pointing out, then they probably wouldn't have been able to meet the burden that's higher than that of beyond a reasonable doubt. And for some reason, Sim Gill and Daniela Rivera don't understand that concept. The other interesting thing is, in the same case of Jefferson versus the state of Florida, the appellate court is saying about judges there, should our interpretation of the text of the section not reflect the legislature's intent, it is up to the legislature to clarify its intent by amending the statute. Unless and until that occurs, courts are duty-bound to carry out the legislative intent by mandating that the state bear the evidentiary burden of overcoming by bringing forth clear and convincing evidence at an accused or an accused facially sufficient prima facie claim of self-defense immunity from criminal prosecution at a pretrial hearing. And again, for whatever reason, this concept is lost here in the state of Utah as we apply this law to different circumstances or to different issues that are going on here in our courts. And then this is another case in 2020 that the appellate court cleared up some confusion that was going on. And then here's another one that's kind of interesting and has an aspect that here, because here in Utah, we've had a couple judges say, well, jury should be deciding this, not us. But that, what about plea bargains? A jury's not deciding that. So in this case, they're concerned that a jury should be deciding these, not judges. But again, the appellate court in Florida clarifies that. and says that no, that this is the law and this is how we go forward with it. And then this is another case in 2021 that the appellate court, talks about the application of the new burden that the state has to meet. So one of the more insidious, I'm kind of switching gears here, going back to the report, another aspect of it that I believe is one of the most more insidious concerns that I have is the way Sim Gill characterizes this new law, that it's a get out of jail free card. And again, you can see the date of this report, this news report, November 15, 2021, it's not working. And then he claims that it's a get out of jail free card. But then several months later, we have a case that that a murder, this man is a defendant, committed murder, and the title says that the 2019 murder case is headed for trial after prosecutors dodge Utah's new self-defense law. And to me, that's a mischaracterization of what happened, because the law itself says that you cannot you cannot go to a pretrial justification hearing if it's a domestic violence, an act of domestic violence, which this was. So the title is misleading because prosecutors didn't dodge a new law. They actually applied it and said, no, it doesn't apply to this defendant. So that's why he's going to trial. And then another case happened back in July of 2020. News reports gunman confronts alleged vandals, shoots 2 women driving away, police say. And then earlier this month, Judge Kendall doesn't accept his claim, or he dismisses the pretrial motion of justification and binds the defendant over for trial. So my point is, this isn't a get out of jail free card like Daniela and Sim Gill have characterized it. And because it's very clear, it says that if the state meets its burden of clear and convincing evidence, then you go to trial. And that's exactly what's happened. So this get out of jail free card is really just sensationalizing this new law in a negative light. One of the other things that Sim Gill says to Danielle in his report, that self-defense is recognized affirmative defense already built into the tradition of criminal justice system. And I can just tell you, in my case, there's nowhere, I guess, until you go to trial, which is our point. Why do you have to wait to go to trial or go through all the burdens that come in the criminal justice system to go to trial to exercise this part of the law that says that if you act in self-defense, that these charges don't apply to you? But in my case, when he says it's already built in, well, but where do you apply it? The other thing that Gill, I guess, forgot when he was doing this report in November is a month before, he says, no plea bargains for gun crimes announced in Salt Lake County DA. So if you act in self-defense and use a gun in self-defense in Salt Lake County, according to him, as it stood then, you're not going to do any plea bargain anyway. You're going straight to trial. So again, that shows the wisdom of having a law like this that allows someone who acts in self-defense to demonstrate that at a pretrial hearing. So in my case, I ended up going to we filed for a motion. This law went into effect, as this report here says, May 5th. And then on May 7th, I filed a motion to have a justification hearing. And then Daniela Rivera, does another story. Utah man urged legislators to pass new self-defense law. Now he's making use of it. So in her efforts to demonize me, she's saying that months of delay, that kind of, I guess that it's my fault that this is being delayed. That why would I want to delay, my case and not go to trial? But the thing is, let me skip that, go to this real quick. She can see my docket for for what it is. And on my docket, it clearly points out, we filed for the motion on May 7th, and then it gets delayed. And things get delayed. The prosecutor delays, even a phone conference, the courts delay it. And I don't end up doing a justification hearing until November 29, 2021. And so my point is, yeah, it is delayed, but I'm not the one delaying it. That's just, anybody who's been involved in this process recognizes or understands that delay is not the defendant doing it. So here, Justice Files by Marcos Ortiz did a good report on, the aspects of this new law and its application. While I did my justification hearing in November of 2021, November 30th or 29th, this ruling came out of Florida from this judge, a trial judge in Florida, and he does a really good job at he dismisses the charges against this defendant, but he does a good job in his ruling of outlining the procedural, the legal, and the facts and the conclusions of facts and law, and he goes over the prima facie burden that the defendant carries, and that how that was met, and that the clear and convincing evidence burden that the state has to meet. And he says that the state has failed to meet its burden of providing clear and convincing evidence that the defendant is not entitled to immunity. He says the state has the burden under that act. The facts are simply not in their favor. So he orders the case dismissed. And it's a good outline. And I learned about it through I think somebody sent it to me, and then I found the Law of Self-Defense podcast and it's that book that I showed you earlier by Andrew Bronca. Does a really good job, and I think it was a month or two ago, and I would encourage people that are interested to watch this podcast, either watch it or listen to it. And in other podcasts, he interviews John Tarun, who was the public defender that argued before this judge that ends up dismissing the case against the defendant. But to me, it's a good example of how this law works and how it brings justice to situations that happen to people. And it kind of, I think after you see this, it kind of takes away the bad light that KSL keeps painting this law or keeps, trying to show this law as something negative. So kind of just to get back on track on the timeline with my case, I ended up having my justification hearing, I believe November 29th of 2021. And then the judge said, we're going to, he wanted briefs from the two attorneys, from the prosecutor and my criminal defense attorney. And then we were going to meet, I believe, in February, and he was going to have closing arguments and then give a ruling on my case. At my first, at my preliminary hearing or my justification hearing in November, he actually said that that the defendant has met the burden of the prima facie, a burden that's in this law. So basically here in the state of Utah, it says at a pretrial justification hearing, after defendant makes a prima facie claim of justification, the state has a burden to prove by clear and convincing evidence that the defendant's use or threatened use of force was not justified. The judge actually said that that the defendant, me and my attorney, has met the first part of this, the prima facie claim of justification, that we've met that, to the point that he wanted the prosecution then to give their brief first and then have my attorney respond to it. And he points out that their job now is clear and convincing evidence that I was not justified in using force. What ends up happening is that when Wyatt, who is the district attorney for my case, submits his brief, a lot of the aspects of his brief are actually supporting my position, which is really bizarre. And one of the things here, he says that the timestamps from the video submitted as State's Exhibit 2, which he's referring to the dash cam video in my vehicle. He says, also show defendant was without justification. So he says that, but then next sentence he says, only 6 seconds passed between defendant's vehicle coming to arrest and defendant discharging his firearm. Taken together with defendant and witness testimony, the video shows that the blue truck likely had just enough time to drive approximately 50 feet northbound before stopping and being shot at 7 times. So that's significant because and I probably shouldn't go into the details. I'm not going to. But anyways, that is significant, and I can elaborate on that later when I do a podcast on the incident that occurred that night. At closing arguments, and where I'm at now is March 4th. So again, just to recap, we have my first part of my hearing November 29th in 2021, and then we're supposed to have the next one in February, but that got delayed because of the court calendar. And then Daniela Rivera would probably, say that's my fault. But anyways, it gets delayed, and we're now at March 4th, where we have the second part of my hearing. And in that hearing, the district attorney says that in the state's view, what was happening is that this was a traffic accident and that the blue truck was pulling over like people do after a traffic accident, perhaps to collect information and report to the police. This was a bad traffic accident. Now, let me point out here that Daniela Rivera, I think she puts on Twitter, prosecutor argues, frankly, if this is the kind of behavior is allowed and it's justified, then we're living in the Thunderdome with Mad Max. But of course, she leaves out the part where he's saying that my incident of this man trying to kill me and my passenger, this prosecutor minimizes the whole incident by just saying, it was just a traffic accident. And this vehicle that was turning around to come and run over me, he's saying he was actually just coming back to exchange information. And, when I heard that, it's like, that doesn't even make sense. Because we know for a fact that the snowplow was stolen. So why would somebody who stole the snowplow and is ramming me and trying to kill me and my passenger, why on earth would he come back and to exchange information? So anyways, that was just incredible to hear that. But that's what he's claiming is the state's position. So it's no surprise then that Judge Shaughnessy dismisses my case. He says that, and KSL accurately reports here, Shaughnessy explained that Clara had successfully made his claim that he believed using deadly force may have been necessary in avoiding injury or death to himself. The new state law would then shift the burden of proof to prosecutors, who are then left to disprove that Clara was not acting in self-defense. And by clear and convincing evidence, the judge said, Shaughnessy ruled that the prosecution had not met that burden of proof set by the new law. So that's no different from what the Judge McGillis said in the Florida case 2 months ago. He says the defendant established a prima facie case with his assertion of the facts as presented in the motion in the court, and he says the burden therefore shifts to the state to prove by clear and convincing evidence that the defendant is not entitled to defend himself. And in my case, and in Judge McGillis's case that he ruled on, the state did not meet that burden. Another interesting twist, if you will, to my case is after Judge Shaughnessy here in Utah gives that ruling on March 4th, he says, I would encourage the state to file an appeal to seek some clarity on exactly what this new law means, Shaughnessy said. So, and then he says it could go either way. It should go to a jury. It could go either way. Well, that's been addressed, in Florida in some case law that we're not, we don't have to go to a jury. The law is that we can take care of this at a justification hearing. Then, and by the way, I'll come back to this issue of the appeal in a second. One last thing here that Daniela Rivera brings up in my case that she says the charges filed against Clara, who was also on the Salt Lake City Board of Education, eventually cost him his job. And he was a community organizer with Crossroads Urban Center for 3 years. Clara filed lawsuit against Crossroads in August 2020. And that's accurate. I did file a lawsuit. This is a copy of the letter I got from my boss at the time. He says, I'm not comfortable with your actions on November 23rd and discharging your weapon. And he says, you're an at-will employee, you're done. And I did file suit because I think that's wrong to fire somebody because they acted in self-defense. And there's case law here in the state of Utah from the Supreme Court a few years ago that says employees shouldn't have to make a decision between their life or their job. And so that's the basis of that lawsuit with my employer that's still in process. One of the things that happened, as I mentioned earlier, a case earlier this month got dismissed. Judge Kendall dismisses the case, or I'm sorry, not dismissed, but their justification motion to dismiss their case gets dismissed, which means they're going to trial. And then Daniela Rivera goes on Twitter and says, oh, today's ruling, referring to Judge Kendall's ruling, today's ruling is interesting. We saw the opposite outcome in a similar case last month. And that's just offensive, because then my message to Daniela is go get the book, The Law of Self-Defense, an indispensable guide, and understand these 5 concepts that are related to self-defense. Or hopefully you go back and listen to the podcast that I mentioned and kind of go through the outline of that Florida case, and you'll understand that these 2 cases are not similar. And this is why they have different outcomes. So moving on here, after my case gets dismissed, I went on Twitter and got a picture with my attorney. It was the last day of the legislative session, and just to remind you, the year before in 2020 is when this new law came into place, and then here we are a year later. I'm actually using the justification hearing, and my case was dismissed, and I got my picture with the sponsor of that law to thank her for doing that, because I think as we work this out and iron out all the misunderstandings of this law that people have, it's going to be a great benefit to people. And because one of the things that I've learned in this legal process is, number one, the legal process is nothing but quicksand. You get in it and you just keep sinking, and the power of the state that's invested in a prosecutor to take your liberties is extraordinary. And that's only balanced out by having a defense attorney or a judge or creating laws that protect our liberties against, I believe some of this is overreach by the Salt Lake district attorney in my particular case. So one of the things that I want to mention here in closing is that when Daniela Rivera is doing her report last year, that here we have the representative Linsonby who sponsored that bill explain to Daniela, look, if this law, if the outcomes or judges' rulings are not appropriate, then you can appeal it. The prosecutor has the right under this law to appeal the ruling of a judge, and the Gill, you see here that Sim Gill says it's a misnomer. He says to think that it's available, that active remedies that are available. He says it's not going to happen. He says the Utah Attorney General's office is the only agency that can appeal felony cases. He says it's not an automatic thing, and he says it's at the discretion of the Attorney General, and that we would need to convince. Okay, then do it. That if that's the law, then do it. I don't understand when I read this, why he's whining about this. If you have a case, then take it to the Attorney General, and this law says you can appeal. Well, contrary to his, I would say, throwing a tantrum about this new law, he actually did appeal the ruling in my case. So my 7 felony charges got dismissed by the Judge Shaughnessy on March 4th, and on April 1st, even though Sim Gill says he can't do it, he actually does file an appeal. And the law says the state may appeal a court's order dismissing a charge under this section. So my point is that this law works, because if you disagree, like he disagrees with this ruling, he can appeal it. And guess what? This thing of him saying, well, you got to convince Sean Reyes, the Attorney General, and and he kind of alludes that they're not going to do it. They did it. I got notification from the Utah Court of Appeals that this case is going to appeal, and the Attorney General, Sean Reyes, is on board with it. So Sean Reyes and Sim Gill are on board with filing an appeal, and are going to challenge the fact that my case has been dismissed. So at the end of the day, although it doesn't look good for me that you got this appeal going on, I can at least testify to everybody, hey, this law works. Because if there's a question about the fact that this judge made a ruling and dismissed my case, I got the Attorney General of the state of Utah and the district attorney from Salt Lake County filing an appeal and challenging the fact that my case got dismissed. So I'm here to tell you, all these things that Sim Gill was telling KSL, they're not true. The law says you can appeal it, and it's being appealed. But of course, you see no coverage of this. There's no news coverage of how this law works. It's just all this clickbait stuff about how it's hurting everybody. So in closing, let me just say, at the end of the day, to me, there's this quote that a defense attorney is a warrior for justice, and I can testify to that. So right now, my criminal defense attorney, Clayton Sims, says, let's just wait. We see, fine, there's an appeal that's been filed, and we'll wait and see, because we don't know the reason yet. So what their points are, and when those come up, we'll challenge those and wait for a ruling from the Court of Appeals. So in closing, I just want to say my call to action is to other reporters, report on this new law, and to people at the law school here at the University of Utah and other like criminal defense associations and other groups. I want to do a call to action to let's have some measured and intelligent conversations about this new law and its application and how it works in other states. For me, the benefit that I see is that it's a counterbalance to the power of the state, that I have this prosecutor that's just relentless to come after me and to utilize the power that he has and try to take my liberty. But because I have a defense attorney, because there's a new law here in the state of Utah, it helps to counterbalance what I believe is overreach on the prosecutor's part. But then the only conversation that's going on about this new law is KSL and what I believe is its mischaracterization of the law. So my call to action is, let's start having podcasts and having conversations on a national level and on a local level here in Utah about this new law and in my opinion, how it does bring justice to situations involving self-defense.